Tremendously happy to be here. What are we defending on government? We are talking about Western liberal democracies with functioning court systems. We'd like to explain what we mean by active misinterpretation. We believe that when you have a liberal majority, that you have an opportunity to create new forms of precedent and new kinds of jurisprudence. We believe that what ought to motivate those courts should not be a constraint towards textualism, but rather merely being able to endow a kind of rights that would not be able to be persuasive if they had to argue with conservative justices and make a claim towards the text. We have a lot of reasons why we think this is true on our side of the horse, on the side of the house, but most fundamentally, we believe that progressive courts have an obligation to value progressivism over any kind of abstract obligation to the past. First, what is the role of constitutions within a liberal democracy? We believe that they have two kinds of purposes. The first is to have procedural organization of how government ought to function, and the second is to enshrine rights for individuals. There are a lot of problems with having strict textualism, though. The first is that constitutions are difficult to revise for good reason, because you don't want to change the fundamental structures of how power is developed and assigned within a democracy. The second is that it's impossible for constitutions to be wide enough to actually resolve all the potential questions of fundamental human rights. First of all, because it's impossible to be specific to all the kinds of jurisprudential conflicts that can occur, but second of all, because it's impossible to necessarily relate to and capture all the different kinds of demographics that may be involved within a state. For instance, the fact that it was probably very unlikely for the early United States government to have some kind of conceptualization of how to deal with things like trans rights or homosexual rights or even questions like medical abortion. So the problem is then that it's possible for constitutions to be wrong, to be self-contradictory, to be inexact, or simply to not predict the future. The question is, what should the foundation of jurisprudence be under consideration of those factors? We say that it's better to alter the meaning and premise of the source of judicial power and have an application to the present be more important than a relation to or adhering to the past. Go for it.
So are you defining these two constitutions that contain something like a Bill of Rights, or are you talking about any constitution irrespective of that inclusion?
Yes, at the top I said that it's both constitutions that have that it's acceptable to have an eschewing of textualism, and why in fact we think this will eventually lead to the death of textualism in a way that we think is good. So I think that the interesting thing, right, is that obviously opposition is going to come up and they're going to say, well, what's going to constrain the conservatives from doing the same thing on their side of the house? We're going to bite this on our side and say, yes, that's probably actually a better outcome for everyone. Why is this? Because a strict adherence to a text which has all the problems of being static that we've already identified within this debate, is one that is always going to be inherently socially conservative. It is always going to be one that is not actually reactionary and potentially open to the new development of new kinds of problems and the kinds of rights that new individuals have on their side of the house. Because the problem is that a stricter originalism essentially says that the framing and the context that the Constitution and the Bill of Rights was initially developed under is sufficient for us to be able to predict and understand how we ought to enshrine rights in the long run, which means that it is by definition anti-progressive and not capable of actually defending all people's rights in the status quo. Which means that if all we do on our side is set up a norm where the way we interpret text is and create jurisprudence is fundamentally about logic and argumentation and the weighing of rights and the consideration of future precedents, rather than an adherence only to the fact it's far more likely that courts and these kinds of decisions will be more able to incorporate and protect people's rights in the long run. The reason why is that I think what we defend on our side of the house then is fundamentally a role where constitutions have an intent and a spirit of a certain set of ideals of how we ought to organize the society, but are not strictly dogmatic claims about what is or is not legitimate. And we think that that is far better than a system that looks at specific context and specific words that restrains society and government's ability to have courts actually be the locus and moments of change. We'd rather that be the source of justification on our side. We're happy to murder textualism. We think this will do that. That will be more progressive in the long run. That'll be something that progressives pursue. But the next thing I'd like to talk about is why we believe progressives need to endow rights in this kind of situation and why it's necessary then to be willing to do this. Because notice that it is precisely the kinds of individuals who will not be protected under a strict textualist reading, exactly those demographics we talked about who have issues related to things like new developmental technology or new forms of social organization, or even were demographics back then, but completely lack the political leverage to even be considered in the kind of conversation. Those are exactly the kind of individuals that need the courts to be the ones to defend their rights. Because it is those same conditions that mean they have been historically neglected or are facing new kinds of problems that society will not recognize. It is exactly in those situations when you need the courts rather than democracy to be the ones to define them, because they are going to lack the ability to get to political leverage and organize such that they could use democracy to defend themselves, which means it is in those situations that progressive courts have an obligation to be the source of defending those rights and be the first chance of demanding that they actually have some kind of human dignity. Go for it.
Most of the constitutions that you're talking about now, like Canada or South Africa, already have massive liberal biases in them. You're basically just veilingly talking about the US only as an example and extrapolating to all constitutions.
No, but that's a time bias, right? Merely because those constitutions have been framed more recently, that does mean they're capturing certain things now. But the whole point of our case is that there are going to be future demographics that those more liberal societies won't predict in the future, and so if they continue to have a norm of textualism, they'll be just as non-reactive. Yes, we're talking about this problem in the United States because we have a constitution that has been drafted less recently, but it's an inherent problem of the way constitutions ought to work, which is why our case will always be true in the general case of defending the most kinds of people, because it is going to be just as likely there will be future demographics that we can't predict or aren't protecting now who will need future protection, and vague concepts of human rights are not well designed to protect them, which is why we need to often eschew the text individually so we can actually endow those rights in the broader cases. But finally, why do we think the priority of rights is going to end up weighing for our side of the house? Sure, Tom.
We firmly believe that Kim Davis should have followed the rules as an employee of the state and followed all of those guidelines as a functionary. Why don't you believe that same duty applies to judges?
Well, for a lot of reasons. So first of all, they're precisely the location in the society where those kinds of questions are legitimate, because they don't have a functional role. They fundamentally have an interpretive role. Look, it's the responsibility of the opposition to come up in this debate and prove to you that there's an inherent truth to the text whatsoever, right? As in, the act of misinterpretation means you know that's not what the spirit, what the intent of the text was, or what the context of its framing was at the time. It doesn't mean that you think your argument is inherently a bad way to frame the balance of rights within the society, or can it is the Supreme Courts and higher courts to make those kinds of determinations, because they are the people who can create the kind of groundswell change. Note that opposition is not going to be defending massive changes in precedent. It's merely how do we justify those changes? Because all court systems have to eventually modernize due to the very problems we've identified to you of constitutions being ill fit for future change. What we're saying ourselves at the House then is the point that it's an inherent problem of constitutions. It is better for progressives to not be arbitrarily restrained by the text just out of a sort of adherence to these higher order questions. So fundamentally, the weighing in this debate is that the jurisprudence of spirit will capture and defend the people who need the most defending within society, and it is inherently originalism and strict textualism that is most designed to be socially conservative and be a kind of discursive silver bullet that keeps people from being able to actually be represented in the long run. For all these reasons, tremendously proud to propose.
We thank the PM for those remarks, and we're happy to welcome the Leader of the Opposition.
Opening government in this debate seemed very keen to have an argument with Anthony Scalia, and in that pursuit I wish them all the best. However, realistically, this debate is not between strict textualism and strict literalism and judges doing fluffy nice things in the real world. It is between a realistic conception of court where they try to do their best to be realistic with what that constitution would want, and a world in which people go out of their way to look at a constitution that says something and go against what the logical conclusion is. Two pieces of rebuttal or some substantive then. First of all, about the distinction, what this debate is actually realistically about. There, in a lot of instances, there is a difference between strict literalism and what opening government we're wanting to talk about, where, for instance, constitutions are ambiguous. They don't talk about an issue. What judges tend to do is they take input. Obviously an interpretive thing, but what opening government have to defend, read the motion, right, is actively misinterpret, right? Where instances where the Constitution says something is not a right that you should be given, or the opposite of the conclusion you want to draw is true, these judges are inventing provisions of Constitution to make new things, or taking the piss to some respect. I think Obergefell, sure.
So does the opposition use debate stand for judicial activism?
To some extent, obviously, right? Because that, we're not all the way to the other end, right? We can defend some degree of judges trying to be realistic, interpreting things that is in a way that is consistent with what the people would want. In instances where they absolutely have to do because a constitution says nothing, we don't support them looking at a constitution that says you should not do X and then implementing it because that's consistent with their values. Additionally, we think there are other mechanisms that are in place to fix these sort of problems. If indeed there are other cases, look at legislative mechanisms and look at constitutional review things. Obviously, those are imperfect and more difficult to get through. However, they are far more protected protected against people abusing them once they get into power, as I'm going to talk about later. Second of all, on precedent, they say this is good because even if conservative judges one day get into power, we've implemented precedent that stops them from doing all sorts of silly things. If you can ignore the Constitution and you've created norms where judges actively go, like, what the Constitution says doesn't matter, our job is to just implement our own values. Obviously, they're not going to listen to the precedent, right? Part of the value of the norm setting where you say the case, like the body of case law is important and adhering to sets of rules are important, is it prevents judges from doing silly things in instances because of the fact they can get away with it. They actively undermine that and make it harder for judges to embed things that are really important and values in the wrong one from being taken away by idiotic people who might get appointed to the court because of the whims of one government that happened to be elected at a particular time. I'll make two arguments in this speech. First of all, about legislative backlash. Realistically, declaring yourself as the absolute moral arbiter of society does not persuade anyone of A, the legitimacy of the claims that you make, and B, the moral stature of those claims. As a result, it is eminently realistic that people will vote in society for more conservative leaders, right? That is already a trend that has happened after Obergefell in the United States. It is a trend that happens consistently because people feel as though they've been shut out from a very important part of the democratic process. They feel as though they have no capacity to influence the structures of power that are like enforced abortion. Society. Court might not be able to pass. In 1980, it became part of Republican, mandated policy. They would be pro-abortion, right? And the consequences of that in the United States have been profound for the last 30 years, right? That is the realistic harm they bring to their side house. But second of all, they actually hurt socially conservative, progressive people on other issues, right? I'm going to be realistic. I think probably the biggest socially progressive issue, the most important thing they should face, is probably just inequality, right? That is the thing that affects the largest number of people, keeps the most amount of people in the worst off condition, and intersects with every other kind of disadvantage you could ever think of, right? Uplifting disadvantaged people economically in society is probably the most important thing progressive judges should fight after. There is no court case you can bring to fight inequality. There is no court case to say that people should not be poor and you should progress to support a more redistributive taxation policy. However, when you get socially conservative politicians on the back of having played games with the court system and made people more likely to vote for them, they will implement policies that hurt those poorest of the poor. They can justify why maybe this policy helps some people for progressive instances in the instance where they're lucky enough to get a court case for them that clearly delineates what they want and when they have enough support to actually get that court case through. It does not help literally everyone else who are the majority of the stakeholders in the debate, and we think that is important. Second of all, principally, we think it is just nonsense to suggest that this is a consistent thing for what progressives should stand for. Just because you support in progressive values, probably, I hope, does not make you additionally a fascist, someone who thinks that, like, my conception of whatever things I believe are normatively true should just be imposed on anyone, regardless of any checks and balances on me, because apparently I'm absolutely morally correct. Sure.
So how much in the democracy is a deliberate misinterpretation of the will of the people? Because we're giving more power to some groups in the society who are not represented properly. Do you believe that these are legitimate?
Sorry, I didn't hit the first bit.
Power sharing bills are a deliberate misinterpretation of the will of the people because we're giving more power to minorities in a society. Do you believe that these are legitimate in WA?
Power sharing bills. Because that's like really specific. Okay, probably in some yeah, but I'm happy to say I don't think they're principally consistent, right? There are some instances where people apply them because they think there is a massive utilitarian benefit. I would think they are principally like not very legitimate, and like some of them don't. Have a policy because we're going to admit you have to to power. We have
I thank the Leader of the Opposition for those remarks, and I'm happy as well to acknowledge
Constitutional democracies are designed to fundamentally be rights-maximizing institutions. They're designed to protect the individuals within them and make sure that despite the democratic rule of that nation, the rights that are afforded to individuals cannot be overridden by a tyrannical majority. The problem is that there simply is never a way to foresee the necessary functions of a rights-granting constitution, given that the arc of history means that different groups, different challenges, and different claims to rights will necessarily come in the future. The problem is that it's not sufficient to say that you'll just look at the existing constitution and misinterpretation becomes a necessary good of the progressive cause at the point that in order to enshrine a new right, you have to assert that a constitution grants a right that just didn't exist before. And so we think that it is fundamentally necessary that those progressive judges are able to actually do that. I'm going to do some extensive refutation of what we just heard out of opening opposition. Then I'm going to talk to you more about the true way that we need to expand rights and the comparatives in this instance, right? So I think that recognize that the first thing that they talk about is like, look, that there's other mechanisms to solve. There's things like legislation. There are other ways that you can rally around this. They don't actually delve into this, and they don't say why this would actually be something that would necessarily be a viable or functional way to afford these rights. In fact, we found quite rarely is that the case. That's precisely why so often it is watershed court rulings that actually allow for the foundation of those rights or any legislative actualization of them thereafter. Recognize that this is completely non-responsive to the argumentation that John gave you, that the exact sorts of people that are excluded from the formation of a constitution, who are not considered in the rights granting of that constitution, are also the exact sorts of people that usually are excluded from having significant sway in a democratic process by virtue of their numbers or by virtue of their political state in that particular country, means that they're very much unlikely to be able to win this through some sort of majoritarian win, right? Recognize that the advance of gay rights could only happen after, could only truly happen in earnest after there were things like overturning precedent about the role of sodomy laws, right? Recognize that you need to have these sorts of rights protections that simply decriminalized people's acts of love in the first place, rather than, because beyond having that support from the court, they simply weren't going to win just from a purely democratic standpoint, right? So, I think that they need to actually prove that if they do believe that the expansion of rights is something that is good and that it is immoral to deprive human dignity and rights from those excluded minorities, they need to prove that there's actually a realistic conception that you ever could have had the same sort of democratic outcomes that they say are like a viable mechanisms, right? But the next thing they talk about is like legislative backlash, right? And so they say that the problem is that when you go through this process of misinterpreting, to have more conservative policies, people are going to be very upset, and everything's going to basically get worse. I think that this is like really non-unique and really not fully developed, right? Recognize that this is always the role of reactionary politics. Like, I think that you can't say that people, like a progressive ruling, whether or not it is a misinterpretation, and recognize that judges usually use their knowledge in their position to make it seem like it's not a misinterpretation, right? We're talking about them knowing it's not a genuine interpretation of the Constitution, but that it's the right thing. But you still have to write a decision and ground it in logic and explain why that's the ruling that you're making from your position of a justice, right? So I think that often this is something that already happens in the status quo, right? Like when we talk about the things like the creation of privacy rights to enshrine abortions. These are the sorts of things that happen all the time. I think that you could also argue with like the way that sodomy laws were handled in the United States, those sorts of things. I think that the thing is that it's opaque to most voters whether or not it was a misinterpretation. The thing that they're upset about, rather, is the fact that it is progressivism winning. It's unclear to me why conservatives are more likely to have backlash against a questionably misinterpreted version versus it's just the actual content of the thing that they are upset about, right? So recognize that this is also just an argument against any progressive ruling, regardless of whether or not it's a misinterpretation. This just is an argument about reactionary politics. But recognize that beyond this, I think that you also have to look at what happens after you make that ruling, right? What is the alternative on their side? They're saying don't misinterpret and don't actually allow for the enshrinement of that right. Then you have a court standard and a precedent that says that is not something that you can ever then bring as a reason that a piece of legislation or discrimination might be illegitimate, right? So they might say that it's the short term, there might be reactions of like doing basically creating legislation that is counter to the ruling that they handed down. But the problem is that you can often take those to court. So like, well, they don't always go to courts and get struck down. Yeah, but at least you have a basis to, right? The counterfactual on their side is if it goes to courts and they're like, yes, we did say that isn't a right, that discriminatory legislation is correct and it is going to stand, right? And we think that often this is usually a matter of time and outweighing the reality as opposed to something that like is fundamentally never resolved. And the comparative absolutely weighs out in on our side. I'll take opening if they have one. Yeah.
Unless you're arguing that you're not getting more liberal decisions, you have to accept that you'll have a substantially more backlash. How are you protecting some of the most important progressive interests, like economic rights, when there is no court case for them to defend themselves, but they do have to deal with conservative people in the legislature?
So my argument is whenever there is progressivism winning, there is always conservative backlash. That doesn't mean I want less liberal progressivism. It just means that that's something that you have to deal with in the short term. Like, it is completely non-unique to say that people are reactionary against progressivism. And they think at the point that we're actually creating more liberal protections for people to be upset about, and at least there's some sort of grounding in them that allows for people to then take those to the courts and actually have those protections enshrined. I think that that's hugely, hugely obvious. Okay, right. Okay, so I think that they say like, they say the legislature may then create conservative and discriminatory actualizations of these policies, recognize that you can only strike them down if you actually have a basis to be able to actually take those things away. You only have a basis in the court to be able to undermine those discriminatory pieces of legislation. So, okay, furthermore on how you actually need to be able to expand rights, to be able to, you actually need to have to actively misinterpret to ever be able to expand rights. Recognize that there simply isn't this sort of definition within these constitutions that could ever have this same sort of prognostication of what rights are going to become necessary in the future, right? We think that fundamentally you have to create a misrepresentation because the context in which these constitutions were formulated are no longer the relevant context of our understandings of morality, our understandings of personhood, as they go forward in the future, right? Like literally constitutions, like I recognize there are new constitutions and we say that yes, there are more liberal constitutions, that's good, but in 100 years they're still not going to be as liberal as the times around them. This is the example that we see with the United States Constitution, where we see that it was formulated under a world where literally an entire race of persons were not recognized within the formation of that constitution, but that we need to recognize that the morality of those times should not be the binding textualism by which we make adjudications for the future rights of individuals. And given that often the very nature and text and spirit of those constitutions would be exclusionary to groups that we think the rights are relevant to. Look, rights of individuals who are living and breathing today and providing for them a legal basis for recourse against abridgments of those rights is more important than an arbitrary dedication to a dead document written by people whose morals we would abhor today. All these reasons, proud to be opposed.
When conservatives woke up in an America that had legalized gay marriage, what they found was not a decision that had been made legitimately by the people, but instead a bunch of tosh written by Roberts talking about how people have a right to love. A right to love that is found in no other case law, a right to love which doesn't appear in the Constitution, but merely a load of waffle constructed to justify a view that he decided that ought to be the decision in Obergefell. We believe it is disgusting for judges to misconstrue what the Constitution states and actively go against what their duty and job is. And we believe as a result, even liberal individuals ought to recognise this and stand back from the fact and recognise the fact that they are functionaries of the state who have been appointed to do a job rather than be the arbiter of all moral justice. 2 points in this speech. First, I'm going to look at the practical impact. Secondly, I'm going to look at the moral duty of judges. First, to the practical impacts. So we've been told that we haven't shown that there's going to be any specific backlash that would occur as a result of a misconstrued decision being made against a decision being made through the legislature or indeed a non-misconstrued liberal conception. Well, note, there's a very obvious distinction here, which is that when you have legitimate reasoning which is backed up by law and is backed up by the very role you're meant to be doing, there's a huge difference between doing that and inventing a right to abortion from vague promises to privacy that exist within the Constitution. That is the key difference, and that's part of what mobilises people. When they know that judges who have no right to be able to represent their views have taken it upon themselves to take decisions away from the people and instead put them in the hands of an unelected group of a small number of individuals who meet to make a decision. That is the key difference, and that's what leads to the backlash we see. So that is why, for example, if you look at the pro-life movement in the United States before Roe v. Wade, it was an incredibly small group of mostly Catholic individuals who tended to be lawyers and doctors and other professionals. What happened after Roe v. Wade was there was a huge change in what the pro-life movement was. It was now a grassroots movement that had millions of people across America mobilized to prevent abortion. What that meant was that a huge evangelical inflow occurred into the group, and as a result, the movement became far more radicalized. This is a group which has managed to achieve results which stand against what liberal justices wanted to achieve. Because note that for 20 years after Roe v. Wade, there was only one abortion clinic within the Mid-South-West. And the reason that was because even though there were nascent movements to create pro-abortion legislation within the South, those were defeated by the fact that now the decision wasn't one that might be made or legitimately justified. It was one that was apparently so obvious to a group of liberal justices that it didn't need justification. And when you're someone who needs justification for a policy to occur, that's what mobilizes you to fight against that. That's why in the wake of liberal misconstructions of justice, we see Republicans being elected into Congress. That doesn't only affect social policy, but it affects economic policy, which is an even more important dimension to the vast majority of oppressed people who suffer as a result of cuts in welfare or the poor provision of services. The government team are prepared to leave them at the side and only achieve changes through the avenues where we can achieve it through judicial decisions, whilst leaving those who can only be affected by the decisions made by Parliament at the side in a ditch, and as a result, far worse off as a result. Let's look that we were told. We didn't explain why it was that legislation can achieve change. So empirically, we shouldn't need to explain this because the empirical results are fairly clear. Note that many other countries have legalised gay marriage without a misconstruction of justice occurring. For example, Ireland voted on this decision. Australia is likely to vote on this decision. New Zealand did it through its legislature, and in fact, most US states had made the decision. So by the time we got to the point where the Obergefell case occurred, the vast majority of Americans now lived within states where gay marriage was legalised. Some states might have lagged behind on that, but there would have been greater movements within those states for change to occur, and there would have been greater legitimacy to those movements had the court not taken upon itself to deprive everyday Americans of the decision that they deserve. Let's now look at the duty that we believe that judges have. We believe that when you construct a system of laws, you're not aiming to construct a system which acts for every particular circumstance. What you're aiming to do is construct a consistent network of principles and ideas which are able to be applied, and generally when applied will help society to get the best results possible. So this doesn't prove your case, but let's see why you think it does. Closing.
So the author says that I cannot work on the subject. However, most professors say this is something which is legitimate because they update what they're thinking over for the people to have a good life. Do you think this is something that can be also calculated in the concept of the state?
So yes, it can, and that's why there are natural changes within interpretation over time, as people recognise that the context of the society does change. But what doesn't change is your ability to be able to suddenly decide that you're going to invent a right that was never in the Constitution and can never be reasonably construed as having ever been there within the first place. We're not saying that the Supreme Court ought to act as if they were living in the days of the Founding Fathers. What we are saying is that they need to act consistently and do their jobs by interpreting case law and precedent and the law that they are given in such a way as to maximise the belief in that system and maximise the overall benefits that are able to come through from that system. We believe that when you construct a system of laws, what you do is construct a designation of what is moral and what is not that won't necessarily apply to every single circumstance, but works overall. And we believe that for something to be moral, it ought to be something that can be consistently done by everyone. Note that not everyone can construe the Constitution to their own means, and as a result we believe that's illegitimate of people to abuse that system and take it upon themselves to do so. Why is this important? Note that there are many aspects of the justice system where we recognise more important principles at play than what the immediate results might be, even though we've shown those immediate results are going to be bad in this particular case. So in cases where we have evidence that has been gathered illegally from individuals, which might yet be useful in gaining a prosecution against them, we don't use that evidence because we recognise that there's a system that we generally need to maintain where we use only the legitimately gathered evidence that is done within the system and within the rules and laws of that system. When you throw away that and say that people are allowed to construe any decision as a result by the mere fact that they happen to be one of the privileged few who are appointed to make these judicial decisions, you throw away the rights of everyone else that have been constructed within a system. This is an incredibly arbitrary rule. We don't believe we ought to be ruled by a dictatorship of a number of judges. Instead, what we believe is that people ought to do their jobs and interpret the Constitution and precedent as they should be paid to do.
And welcome the member of government. Yeah.
Dear panel, well, the debate stands at this point is as follows. Opening government give us a great case about why misinterpreting the Constitution can actually grant more rights to those oppressed minorities that we want their rights to be protected. However, opening opposition say two things. Firstly, they say this is just not the role of judges. This is not how constitutions should be interpreted, or the whole dictatorial judging that they're talking about. Secondly, they tell us that this can be achieved through other means, through legislation and so on. We're going to extend on these two issues. We're going to explain to you firstly why it is an essential part of the role of judges, specifically to interpret and to misinterpret and to renew the Constitution as it exists. Secondly, I'm going to explain to you why you can't get the same results through Parliament. Before going into that, a few points of explainer's rebuttal to what we heard from previous speaker. Firstly, he noted his comparative about Roe v. Wade basically goes as follows. We have a mass movement that we didn't have in the past, and this is very bad. However, note that we do have a lot we do have a case today in which Roe v. Wade was not reverted, in which, yes, you can get an abortion in the United States, which was illegal before what he was mentioning. Note, he doesn't actually explain to us why it is even if there were some movements in the South, what is the likely scenario that legislation would have been pushed through. Note also that what may be true for abortion, which applies to 50% of the population, does not apply to groups that are smaller in percentage that have the problem of intensity of preferences that can't actually be represented in the same manner. I'm going to touch on this in my second point. Then he talks to us about the example of a lot of other places that have legalized gay marriage. For example, Ireland. Why does he give Ireland? Because it is the only example which you can give for a popular referendum that did exactly that. Note that the example of Ireland came after a ruling in the United States and the public discourse that created the legitimacy that gave to the process. And we're saying that is a key function here. And also we're saying, yes, we obviously should apply it only in the cases where it is necessary, not in the cases where Parliament would vote for it anyway. Let's talk about why, and then note their entire backlash point. Is basically says the following: people will see that the power is being taken from them, therefore there will be backlash, therefore they become more radicalized. However, note, in answer to our clarification, also as part of their case, they acknowledge judgmental activism. They acknowledge that judges should do this sort of things, meaning the entire backlash happens on the other side of the house as well, just by the fact that you have a court with a majority of liberal people. You have that by the fact that most of them are not legal, most of the average intelligent voter is not a legal expert, and when the Republicans Republicans tell him that this was misinterpreted, he will see it as misinterpreted. We simply believe all their backlash happens on both sides of the House without the benefits that we bring to you. Let's talk about why this is actually the function of why this is actually the function of judges and what they should do. Because basically, opening government starts by telling us that circumstances are something that changes, and you cannot foresee for any future. You can't legislate for any future occurrence. And the opening opposition, however, tells us that the one that should fix this is Parliament and not the judges themselves. However, what we're telling you is that the Constitution is basically a set of norms and ideals that govern our society. They derive from them. We derive the specific liberties or protections that the Constitution is supposed to provide us with. For example, note that if a Constitution states that, for example, the spirit of this nation or the spirit of our law is the notion of equality, this is not something that is, or the meaning for a Constitution is because this is something that is not up to democracy, but it's the basis for democracy. This is why we give, for example, one man, one vote. This is why we believe people should have a ruling over their own lives. What does this tell us? This tells us when the spirit of this Constitution actually comes into engagement with a specific text within that Constitution, the spirit of the Constitution is the more important part within that. And specifically, judges are the ones that should make this decision. Why? Firstly, because they are experts specifically on the Constitution. They know what that spirit is. They are the ones best placed to interpret it. Note also that specifically in most cases, countries that have a Constitution, judges are also a political appointment, in the sense that they are people appointed specifically by a party in order to, so they have both the understanding of the Constitution, the understanding of the spirit of that Constitution, and the understanding of political tendencies, political wills within people. This is critical, because we're saying they are that exactly their function is to the notion that this Constitution is something that moves forward, is something that progresses, and their function is to progress it in that way, also when disregarding the text in favor of what the text should have been, or what it should have been given current circumstances. For example, the fact that Roe v. Wade is actually based on privacy, on the right to privacy, which is obviously not what not the initial intention of the right to privacy on the Fourth Amendment. Now, note that Dan gives in a POI the example of religion, because yes, religion is the main function in which we see these things happening. Take the Bible, how it was in the past, and obviously it is a terrible text in the sense that it executes basically anybody. However, no religion operates by that. Even IS are actually more moderate in their definition of the Bible than the original. Why is this critical? Because note that the backlash this is the place where it's most prone to backlash. This is the place where you would say the only function of a priest is to uphold the rule of the text. However, they initially misinterpret and actively misinterpret the text in order to create a more liberal religion that conforms with the realities. And note, this does not have the backlash that they are talking about. So we believe this is something that works over the long term. Before I go on, I'll take closing.
If you think the constitutions are so constantly outdated and tedious and constraining, are you happy to do it? Why don't you happy to do away with them?
No, we are not happy to do away with them, and I'll explain that right now in my second point about why Parliament cannot enact these specific changes. Because we're saying basically we have the problem of intensity of preferences. That giving rights to small groups is specifically hard for Parliament to do. Firstly, because Parliament is skewed towards people who have a high percentage in the population, no matter what their true preferences are in a specific, or how strong their preferences are towards a specific issue. Moreover, they haven't. You're out of order. They have a very clear bias towards people with more political capital, with more economic capital, with more cultural capital. This is exactly why we need the Constitution in the first place, to ensure that it will be very hard to go against the rights of individuals or against the rights of small groups within a society. However, so we say that parliaments are just badly placed in order to enact these changes, and specifically to enact them fast enough in a system that progresses and to stop people from being oppressed. Note also that we believe they only act in cases where there is a strong message by this group and a strong struggle by this group to gain that legitimacy, because otherwise they don't do it every second day of the week. Basically, it only happens in cases where you do have a very strong preference from a group which cannot be reflected by Parliament. For these reasons, we are proud to propose the motion.
I thank the Member of Government for those remarks, and I'm happy to welcome the Member of Opposition.
right. As a closing opposition at this stage, we think there are three things to talk about. One is legal interpretation. The second one is in the context of bills of rights. And the third one is the thing that I POI'd right at the start, because it became pretty clear that nobody was actually planning to talk about it, the actual procedural component. That's what makes it a fucking constitution in the first place. Not that it's got a bill of rights, it's that it tells you how your state operates, not what the government's supposed to do, all right? So let's start on the legal interpretation at this stage, all right? Now, we're going to be a little bit more charitable than our OO was about the government side, right? Because OO seems to think that they're talking about formalism, which is to say that every word has a very specific, almost like scientific meaning to it, and that, that can't change, and that's what they're being constrained by, right? We, maybe, but we're going to be more charitable to you, and we're going to say that government's probably talking about intentionalism, all right? Which is to say that you interpret the law with the idea that you're trying to work out what the lawmakers were intending that law to do at the time they were writing it. Now, we're going to concede that if intentionalism is in fact what you're constrained by as a judge, then it does make things like transsexual rights a little bit complicated, because, the founding fathers probably weren't thinking about transsexuals. That's true. Maybe they were, but anyways. The point is that kind of thing could be constraining. But the main point is that we're not constrained. We're not committed to intentionalism, all right? We are committed to purposivism. Purposivism says that you interpret the law with the purpose of that law in mind, not necessarily what the person who wrote it envisaged at the time. It's not the actual state of mind. It is the purpose of that right, independently of who wrote it. Which is basically to say that, I'm sorry, CG, but your whole extent, or half your extension at least, we just fucking concede that, alright? Like, the spirit that you keep talking about is equivalent to the purpose of the right that we're talking about. You can very honestly interpret the Bill of Rights, or any given right in it, in accordance with purposivism. If you're going to tell me you can't do that, I raise you the entire South African Constitutional Court, which does that on a daily basis, alright? Don't tell me that they're all lying to us, alright? That is the way that the purposivism interpretation works. There is an entire system of constitutional law based upon it. The Canadians also do that, for the record. We have to recanon Canadian law as well in South Africa, though I wish we didn't. And the point behind all of that is that the purpose is quite easily adaptable, all right? The purpose of something like freedom from sexual discrimination, it's quite easy to see when you look at a transsexual who's come up now and you go, look, you're being discriminated against. It's got something to do with the sex that you have or don't have, or something in between. Clearly, the right to sexual prevention from discrimination on sexual grounds, that's going to cover you. Even though we can be pretty sure that Adam, what's his name, or whatever your old people are, they didn't envisage it, but they definitely put forward a mechanism that protects them all the same. Adaptability is something quite capable of being encapsulated within honesty. So boom goes that whole thing on legal interpretation. Second thing to talk about then, the concept of the Bill of Rights, all right? Now, when we POI them again, they once again just sort of flap me away and pretend like I'm not listening, and they say, this is really just, old constitutions are the problem here. Pretty much conceding that if this was applied to any new constitution, it would be massive overkill, all right? You try applying your metric of how to operate to a Bill of Rights that's already got a whole lot of liberalism in it, you end up just being like the craziest of the left, all right? Everybody can see through you under those circumstances, and you also end up being completely disproportionate. Your whole case is that they need to counterbalance all sorts of other problems. There's nothing to counterbalance in that instance. But let's take you in a slightly more charitable scenario here, all right? And let's say that we don't have to worry about that scenario already existing. The problem is that when you, as the Constitutional Court, start deliberately misinterpreting it, let's not talk about the citizens, because true, the citizens sometimes do, sometimes don't know what's going on, and maybe they backlash or don't backlash based on their gut instincts. The fact that Donald Trump's doing well tells us that gut instincts aren't reliable. But what we do know is that the government understands exactly what's going on, all right? And when the government quickly works out that the fellows on the other side of the state are playing an ill Machiavellian game against them, they start playing the Machiavellian game back. And what do they control? They control legislation. There's a damn sight more legislation out there than there is constitutional text. What does that mean? They start writing their legislation to deliberately counteract that. They write it as conservatively as possible so that they can stop your deliberate Machiavellian attempt from being successful. Legislation controls far more of your or my life than does the Constitution, all right? Constitutions are the last port of call in any kind of legal dispute. Sorry, ma'am, I'll take you in a moment. They're the last thing that you go to. Most court decisions are not taken by your constitutional court or equivalent highest one. They're taken by like a high court level, all right, a much lower level, and they make their decisions based on legislation, which basically means that if you're worried about the man on the street, you just screw him over. Shoot.
So if the purpose of the Constitution is generally to give and protect rights, what would it be protected under your advocacy? You just redefined the genuine definition of the Constitution so broadly, you've become the gov side.
No. And what we're telling you surrounding that is that that interpretation is something available to them based on what's already been given. And I'm telling you that what's already been given is very different depending on which context we're talking about. It's your fault for not being context specific, madam, not mine. Let's move on to the second thing here. This is about the old constitutions, all right? And the question that they basically all want to talk about is the USA, and they explicitly concede that when they talk about that, all right? And what we're going to say here is, firstly, all of the above applies. And the second thing I'm going to say here is that in the USA, the major barrier is not the courts, all right? Something like trying to pass gun control laws is because of political lobby groups that get their hands on Senate and House representatives, and they block people from being able to put through the legislation that would have fixed it in the first place. All right? So don't tell me that's because our judges aren't being Machiavellian operators and disingenuously disingenuously interpreting the law. That's because of political lobby groups. If we could get that damn thing through to the highest levels, we actually think there's a genuine possibility that they'd say, hold on, a degree of gun control is not such a bad thing. But they never even get there because it all gets crushed because they don't want that thing to see the light of day in the American Supreme Court. That's got nothing to do with dishonesty on the part of courts, although a lot to do with the dishonesty of American politicians. The last thing to say here, and we can leave a bit more of this to be spoken about by Brindy because of time, but the last thing I want to quickly put forward so that you have a chance to respond to it is the idea that procedural laws shouldn't be tampered with. They are the state, not the government. When you start playing Machiavellian with the state, you lose confidence not just in the government, but in the state apparatus. And that means that voting no longer works as a mechanism for restoring confidence. If you lose confidence in the government, you can vote them out, put another one in, and the state remains unaffected. But if you lose confidence in the state, which is what it means to mess with the procedural aspect of a constitution, there's no amount of voting that can deal with that. Then you've got to resort to revolution. And I don't think anybody wants that in this debate. Thank you very much.
I thank the member of government for those remarks, and then I welcome the government witness.
Is in the core of the state. It means, and judicial activism is something that they are fine with. What does it tell you? It means that they are comparing to a world in which the courts are already politicized. They're comparing to a world in which there is already high incentives to put conservatives into the court. They're comparing to a world in which the vast majority of the backlashes, the vast majority of lack of confidence already exists into the first point in which I'm going to compare and tell you why we're going to get more progressive rights. Let's start specifically there. As said, what is a comparative here? The incentive of the place, conservative judges is going to agree on both sides of the house, specifically if they consider the fact that ambiguity is something which is predominant in these constitutions, which mitigates a lot of parts of the backlash. Moreover, note the other thing. They cannot control what is going to happen if a conservative judiciary is actually going to follow a progressive one. What does it tell you? It's a prisoner dilemma classic situation in these cases, which means that you cannot say that a conservative court won't do it anyway, which means that there is no guarantee that they're not going to push these crazy things that they're talking about. There is no causal link to say why if the judiciary in a progressive court is going to do this, why won't or create a fact that there's going to be more of a chance of a conservative court to do the exact same thing. Moreover, and here is a crucial point, what things are actually going to change? Because recognize the following, they may be not attached, by being liberal does not mean that you are stupid. There are things, the cases which are going to pass and are going to be misinterpreted, by necessity must have a degree of public support to it. Case in point, or Wade in the time, case in point, the gay rights in America right now, and I can go on and on and on. Why does it matter? A, because I'm going to use it in the legitimacy point in a second to show you that they are things that do have public support. But moreover, it means that people are willing to put time to fight for them. They're willing to collect money in order to fight for them. They're willing to actually put the governments that are going to be there into the court themselves. It means that A, they are going to be connected, but B, they are going to be things of high profile and things that are likely to be sustainable over the long term, because there is enough public pressure in order to persuade the judges that something should happen, which means that it's not likely that a court is going to reverse it if the court is going to change. In cases like New Zealand, you think things are going to happen anyway, the courts will probably just not do this. In the cases, and the vast majority of the people, as we tell, another point here, it's actually kind of hard to repel them in future courts if you're already given the right. It's much more harder to actually take gay rights from everyone into the fact that if everyone can get married, because you are likely to get a lot of angry. People are just going to be normal in order for specifically that. You're not just going to take everyone's right. It can happen in some cases, just less likely. Moreover, in the vast majority of the public, the vast majority just won't know that something is happening. Specifically in the United States, some part of the population believes that Bush brother and Bush Senior and Bush Junior are actually triplets, which means that a lot of people just don't know what is probably written inside the Constitution. The vast majority will not know that any abuse were made, but moreover, a lot of them are going to believe that any interpretation, because of the ambiguity, is a misinterpretation of the government, even if you accept the case of intentionalism in any way. Presidents are more likely to be created. And as a bottom line to this point, we say that all of the damages are likely to a high extent on their side of the house. The backlash is likely to a high extent on their side of the house as well. However, the unique advantage of actually giving for women throughout the generation, the fact that some people can have an abortion now, the fact that some people can marry now, the fact that presidents are created in order to ensure these rights, the fact that a lot of time it is going to be hard to take them, the fact that progressive courts in the moment do not have the guarantee that conservative courts are not going to do the same. Even if in some cases the regulatory of the legislative branch is going to try and to upheaval these exact rights, it doesn't mean that we shouldn't fight, because the comparative here is to a world in which nobody have any of them at all. This is why we're going to get a more progressive world. But before I continue opening, yes.
The backlash against Roe v. Wade didn't lead to total repeal, but it did lead to Planned Parenthood v. Casey.
Yes.
The RNC adopting a nationwide pro-life
All
plan,
the same countries in the world have given women the rights to abortions. We say that what we say is that even if you do not believe that this should be the case, or at least in some cases, the comparative in a more or less liberal world is to a world in which we do not have any of these rights, which means that it's specifically in the comparative here, it means that no one would have had these rights. But why is it the role? Note, OG's case is as follows. Its spirit cannot be consistent because it was a long time ago. It is reliant upon the idea that why Parliament cannot change it. We tell you a couple of things in addition specifically here. A, it is only a sake of formality of norms of the society, which means that right now you do have the right to update it. B, and here is a crucial point into the legitimacy of this debate. We tell you the following. The judges that are put there for a long period of time know the Constitution and its spirit better in comparison to parliaments. Why does it matter? Because if you know the Constitution better, it means that you are better aimed in order to protect the meaning of the Constitution, even if you are aimed to misinterpret it, you are a better protector of it because you know the interpretation of what should be and what should the ideals be right now. Because people that work in the parliamentary are going to change more often. These people are going to be less of a knowledge of what you should achieve. Moreover, these are people that were elected by parliament in some period of time, which means that they are connected to the public wills all in all. They were voted, which means the public is pawned specifically to them. Representation is actually likely by, not directly but indirectly, specifically there, which means that it is the role by comparison. We're going to get a more progressive world. This is the role. We beg you to oppose the motion.
I thank the government whip for those remarks. I'm happy to welcome the opposition whip. Yeah.
Government's side is correct when they point out that we agree with a lot of what they're saying. That's because they've misconstrued what it means to interpret things legally in the way that we do all the time at the moment. Specifically, the words that they had to defend, that I forgot on my desk, are the actively misinterpreting the Constitution. We give you a school of interpretation, not a misinterpretation, and we say that this school of interpretation, which is the one that is employed, is a legitimate one to defend on opposition bench. Notice that a huge amount of their case is not actually about the misinterpretation when they say things like, well, we really like the spirit of the Constitution. Well, we really like the, meaning of the Constitution, where they say they like having a Constitution. They're not talking about exactly what the motion is, and that's a problem for their side, not for ours. I think another thing, interestingly, that they talk about is that they say that they like checks on democracy. Well, that's what a constitution does, right? And I think that when they start saying things like, well, we think that it's problematic to have to misinterpret a constitution in order to make sure that minorities have rights, that's the role of a constitution. You don't have to misinterpret it to do that, which is to say that a huge portion of their case has to fall out of the debate because they're talking about things that are what the constitution does and saying that it's bad that a constitution doesn't do them. But that just means that they're misunderstanding the constitution. I think the other area where this is incredibly telling is when they start pointing to examples in the past and say those were misinterpretations and so we like them because they were liberal. The point is that we don't know that they were misinterpretations because we're not legal experts and because they concede that you wouldn't know if they were misinterpretations in their case, right? Which is to say then that you can't use those examples. It's not useful, specifically because we've given you a school of interpretation that is accepted that says that this is legitimate interpretation in the vast majority of instances. What have we brought you as closing opposition? We've brought you three things. The first thing that we've told you really importantly is that we think that they've misconstrued constitutions and as a result they've tried to create a problem where there isn't one, where they start hammering on the idea that, well, we're not getting liberal things at the moment. The reality is that we are getting liberal things at the moment and we're getting them through the constitution in the instances where that is legitimate. The areas where we're not getting liberal things from the constitution is because is either because they're not getting there, as James tells you when you talk about gun lobbyists in America, or it's because it literally wouldn't make sense to infer that, because that's not something that works in the Constitution. So, for example, if you take the right to labor and infer a minimum wage from that, that's not the kind of thing that works, or it's like the creation of the right that our opening opposition talks about. That's the things that we're talking about in today's debate. So then I think what becomes important from the analysis that he brings you is that they've misinterpreted how a constitution works and the importance of that constitution. Then the next thing here I think that's really important to discuss is that a huge portion of the way in which this debate's been framed is hinging on the idea that the Bill of Rights is the Constitution. Well, it's not the Constitution, guys, surprise. But I also think that what's important to remember about this is that where the Bill of Rights explicitly stipulates incredibly liberal things already, it's not enough for them to say, well, we need more liberal things and presuppose that liberal is always good without telling us why liberal is good in all of the instances that they can't give any examples of except backward-looking ones that they told us they can't know are actually examples of the thing that they're talking about, especially because they don't actually rebut James, they just tell us that it's on their side, not ours. So So I think that and then when he tells you that what happens then is that governments explicitly stipulate legal provisions to be conservative, that means they can't be overruled by the Constitution. We think that's really harmful because then you have a conflict between the Constitution and the state in a way that's specifically harmful, because the role of the Constitution ought to be neutral, and the role of the state should be to be liberal or conservative, right? The Constitution is a platform on which different governments govern. You can't say that progressive is necessarily good, and then we recognize that sometimes other kinds of parties win elections. You have to tell us why those things were valuable, and you didn't. That was a problem for you guys. So then finally here, when James talks about the importance of the procedural element of the Constitution, I think this is pretty damning that it doesn't get rebutted, because it's incredibly important. Because what happens if you lose confidence in the document that stipulates procedure for your country is that you lose confidence in procedure. And you know what laws do and the Constitution does? It allows society to hang together because it's something that you trust to be neutral. When you have claimants in a court case, they definitely don't trust each other, right? And often, if they feel disenfranchised, they don't trust the government. Because you have laws that they believe to be neutral, they're willing to opt into that society and opt into those structures and trust things like the legal system. If that isn't seen to be neutral anymore, which is exactly what we recognize throughout the debate is going to happen, then you don't have the instance where that happens. In fact, you on the alternate side have an opt-out of this, which is where you see things like in South Africa, people feel disenfranchised from the fact that there isn't a death penalty, and you have vigilantism, or you have things like agitating against the kind of legislation, the kinds of things being passed in the Constitution, and the voting in of more conservative governments to stipulate the conservative laws that go against the kind of things that they want. Then they tell us, well, people just won't know this because people don't understand what's going on. Never mind the fact that the kind of constitutional cases they talk about are getting massive media coverage at the moment. What we tell you specifically in our case that's important is that where the trust matters is when specifically you're talking about the relationship between the legislature and the government, because the government responds to the legislature. And secondly, that lawyers are experts who advise on this stuff. Opening.
Either you agree with opening that the U.S. gay marriage decision was illegitimate, meaning you can't dodge your side with immoral rights deprivations, or you're saying it was legitimate under your broad purpose standard, in which case you're swirling your verdict in obvious overreaching that has no opposite cases. Which is it?
So, we told you that misinterpretation is about explicitly misinterpreting things. I can't tell you, and you conceded that I can't tell you, which is the case, because you told me that they were going to try justify them either way. So I think that that's the problem on your guys' side when you concede that we'll never know either way, but you do lose trust, which means that we think that we can point you to the harms that occurred in terms of our case without having to tell you whether or not it was a misinterpretation. But I'm happy to say that it probably was, and we'd regret it on those grounds because of the kind of mistrust. Okay, so then, what do we tell you that's mostly important is that the point isn't that you're going to lose out on massive liberal gains in general, right? The general case hasn't been that, specifically because if we look at them, it hasn't, if we look at the way in which proceduralism works, that's not the kind of way that we are able to interpret things. The really important reason for that is that proceduralism looks at, the laws used to look at society and say, what is the function of the Constitution within society? As society changes, obviously you broaden the interpretation of the intention to the whole of society, but it doesn't mean that you have to change the procedural intention itself in terms of how you interpret it. And that's why we think it's legitimate.
All speakers for a very interesting debate. We'll give them a round of applause.
Before the CA team announces the winners, I have to do a ceremonial thank you to everyone. So first of all, I would like to congratulate all the teams who broke and made it to the finals. But most of all, I would like to thank all the teams, especially those of you who traveled so far away to come here and to visit Skopje and let us host you at this tournament. So give a round of applause for yourselves. This is actually our second Skopje Open, so we encourage you to come next year, and we hope we provided you with enough reasons why to do so. So the next ones I want to thank are the judges, who I've heard are the best judges at this tournament and are probably here because of our wonderful CA team who made it all happen. For a round of applause for the whole team of judges. And last but not least, and most importantly, I want you to get up and thank all the volunteers who helped us organize this tournament. Hear, hear. right now using the facilities of the Fon University. This is actually a university that supports the debate in Macedonia very often, and we would like to thank the university for providing us with the space to debate here today. And lastly, this tournament was brought to you today by the British Embassy in Macedonia, and the British ambassador here wanted to come. However, he's with his family and spending Christmas there. But he was kind enough to provide us with a video which he wants us to show it to you, so he may say thank you for coming here. So we're going to proceed to the video.
Hi, it's Christmas time. So for those of you who celebrate it, and especially for those of you who celebrate it today, a very happy Christmas. I'm sorry not to be with you, but I hope that this short video message will make a good stand-in for that. For me, as for many Brits, if you draw up a list of favourite parliamentarians, Churchill would be on there, perhaps right at the top. He was considered a magnificent talker, perhaps one of the greatest of the 20th century, but often a poor listener. It's said that he was also very eccentric about the way he did his talking. For example, on a regular basis, requiring his secretary or one of his staff to come into the bathroom while he sat in the bathtub so that he could dictate to them or discuss affairs of state. And I think if you drew up a list of other great conversationalists, a recent visitor to Skopje, Sir Thomas Stoppard, would almost certainly be high on the list too. Strict recipe for how much of each ingredient you need to make up a good or a great debate, but there are some principles that I think will always be required elements of a good debate. There was a recent report in the British magazine The Economist, which incidentally has just brought out a publication in the Macedonian language, launched just last week, which lists Cicero and his principles as still current for all of this. They point out that the principle that it is rude to interrupt another speaker goes back at least to Cicero. He was writing 2,000 years ago, more than 2,000 years ago, in 44 BC, and he argued that any good conversation requires alternation between participants. He wrote an essay called On Duties, in which he remarked that nobody has set down the rules for ordinary conversation, though many had already done so for public speaking. So he then went on to set down what he saw as the most important parts, the most important rules for good conversation and debate. And these were: speak clearly, speak easily but not too much, especially when others want their turn. Do not interrupt and be courteous. Deal seriously with serious matters and gracefully with lighter ones. Never criticise people behind their backs. Stick to subjects of general interest. Do not talk about yourself, and above all, never lose your temper. So these are all important rules, whether they're for everyday conversation or for a more formal debate. Whatever form of exchange, sticking to them is an important part of making it a good debate. And good debates promote dialogue, and dialogue, of course, is essential for oiling the wheels of democracy in any country. This embassy, our embassy here, is committed to working with young people. You're one of our key partners, and we support a range of programs working with a range of different youth organisations here in Macedonia and indeed across the region. So we're proud to be supporting you in the work that you're doing today, in the project you're running today, and we commend the Youth Education Forum for all the work they do in instigating good debate around Macedonia. This House believes that debating is the essence of democracy. This House believes that the creativity, energy, and ambition of youth makes it a champion of change. Once again, a very happy Christmas to all of you. I really hope you enjoy today, and I look forward to meeting you in person one day soon.
Right. So that was Ambassador Charles Garrett, who was really sorry he couldn't make it here. However, we hear that he followed all the debates on our stream, which all of you can see at radiomof.com.mk actually. So I would like for you to welcome, I would like you to thank the staff team from Radio Mof for providing you with the stream, and also for providing you with the stream of WDC in Thessaloniki this year. So please give them a round of applause. And before I finish, I'm going to use this opportunity to give one last announcement. So tonight's socials are at the Old Bazaar at a place called a brewery, actually, translated in English. So we have an open bar there for you, and we have organized transportations. So when you see in your schedule, you would look at it that at 10 p.m. buses will be leaving from the hotel to the socials, and we will leave you there. And tomorrow morning, those of you who are going to, and then you can find your way back to the hotel, whenever you want. And tomorrow morning, the bus for Thessaloniki will pick you up from the hotel, and we will drop you off at the hotel at Thessaloniki. Heads up, we might have a bit of a problem on the border, so bear with us.
What time is the bus?
The bus leaves from 10 to 10:30 a.m. tomorrow morning. Right, so before I give the floor to the CA, I would once again like to thank you all for coming here and welcome you to come here once again in 2016 at Skopje Open, and wish you good luck in Thessaloniki.
So now the top 10 speakers. Enjoyed 8th place with an average of 79.8 is Simonas. Benji. And Aitan. And in 6th place with an average of 80 is Aiting Lee.
Okay. In 5th place with an average of 80.4 is Nick Carverhill. Also in 5th place with an 80.4 average is Ayala. On 4th place with an 80.6 average is John Papantonio. We have medals for the first 3 speakers, which will be given out by Harish. On 3rd place with an 81 average is Thomas Simpson. On 2nd place, with an 81.4 average, is Taylor. The top speaker of Skopje Open 2015, with 409 speaker points, that's an 81.8 average, is Dan Lahab. And to announce the winners will be Amelia.
Just before we announce the results of the final, I think on behalf of the CA team, we would just like to thank the ORCOM and the conveners of this tournament for what has been an excellent tournament, where they have been helpful and the best hosts ever, I think. And they've also run an excellent tournament in every aspect when it comes to org stuff. So a round of applause for the conveners. So thank you to all teams in the final debate. We can make a short roll call. Is opening gov here? Opening gov? Yes. Opening op? Closing gov? And closing opposition. Yeah. We want to thank you first for a very enjoyable and interesting debate. We had a long discussion where we reached a split decision. So on a 4-3 split, the winners of Skopje Open 2015 are opening opposition.